Hello all. Today I'm going to be talking about a case currently pending before the Supreme Court, Gonzalez v. Google. And this case pretty much challenges Google and other internet sites' ability to kind of market their brand to their viewers. Probably make more sense as we kind of go more in depth. Well, let's just dive right in. This case actually began. Noemi Gonzalez was an American attending University at California State in Long Beach, California, and she was studying abroad for a semester in Paris, France, and she was among those killed in a terrorist attack there in 2015 at the age of 23. And soon after this attack took place, the ISIS, the terrorist organization, took responsibility for the attack publicly. And so the family of Noemi Gonzalez sued Google a little later on. It bounced through many lower courts before rising all the way to the Supreme Court. They began oral arguments in the Supreme Court, and pretty much what this case is challenging, or at least addressing, is an amendment called Section 230 of the Telecommunications Act of 1996. This was pretty much an act kind of regulating and kind of setting the rules for the use of the internet. Obviously, when the internet first really came into mainstream in American society, it kind of took the U.S. government by storm. They're like, oh, this whole other realm almost that we have to now regulate. And so this is what that did. The Telecommunications Act of 1996, pretty much saying the do's and don'ts of the internet. And so this Section 230, which I'm just going to read you right from wikipedia.org, give them credit. It says, Section 230 is a section of Title 47 of the United States Code that was enacted as part of the Communications Decency Act of 1996, which is Title 5 of the Telecommunications Act of 1996, and generally provides immunity for website platforms with respect to third-party content. At its core, Section 230, specifically C1, which I'll read later, provides immunity from liability for providers and users of an interactive computer service who publish information provided by third-party users. So, oral arguments have started in this case. There's also a case very similar to it called Tomna v. Twitter, and they're very similar, though there are differences. I'm going to focus on the Gonzalez v. Google case in this video, but it's very likely that the Supreme Court will side for or against the media sites in both the cases, though they don't have to. That's just my opinion. But pretty much, I listened to the oral arguments for quite a while the other day, and it may have been a little bit confusing at first. Even the justices were a little bit confused to the exact argument the, the team representing Gonzalez was making. The lawyer representing them was a man named Eric Schnapper, Schnapper. And so I'm just pretty much going to go down and, well, first, the 230 C1, which kind of is the core of this case. It reads, no provider or user of an interactive community service shall be treated as the publisher or speaker of any information provided by another information content provider. So pretty much what this means is, if I were to make a website where anybody can make blog posts, it's an interactive community about, I don't know, fishing. I'm making a website where people can chat about fishing stories. If somebody gets onto my site and commits an illegal act, this provision, C1 of Section 230 of the Telecommunications Act of 1996, makes sure that I cannot be sued for information said by another person on my platform. I am immune from being sued for another person's actions, even though it's published on my site. They would definitely be responsible for it, as they themselves have said it, but the owner of the site would not be liable. And there's a discussion here during the oral arguments that what exactly is what information does constitute the third party, and what may be coming from the site themselves. And it really gets complicated when you go into social media. And obviously it wasn't around 1996, but it still stands as law. So that is kind of the bar we have now. I believe one of the justices, I don't remember who in particular, said that there maybe the ball should be in Congress's court to kind of amend the rules for an advancing 21st century society. But this suit, first I'm just going to read, so Justice Clarence Thomas was questioning the lawyer. The lawyer actually kept referring to YouTube thumbnails, as he kind of considers the thumbnails of YouTube to be not third-party content, but content published by YouTube themselves. And his basic argument, in short, is that if I was to go and look up a video about like a terrorist organization, obviously after all of this, YouTube had much sharper rules. You can't really go and find videos from ISIS or any terrorist organization anymore, but back in 2015 you could. And so that's kind of why we're here. But you would definitely be getting it from the third party. The first party would be the viewer. The second party would be Google or YouTube, one and the same. And the third party would be any other publisher on that site. So pretty much Mr. Schnapper, the lawyer for representing Gonzalez, pretty much it's their opinion that once somebody watches a video on YouTube and the recommended videos from the AI algorithm that YouTube uses, that the algorithm created is no longer considered published by the owner of the video, the person who originally published the video. Is no longer theirs because it's been made into an algorithm that is created by YouTube, and it's now them who are the publishers, so they would not be third party. They are the hosts of the site, and if it's deemed that they are the publishers of this algorithm that aided and abetted terrorism, well, that would pretty much be YouTube aiding and abetting in international terrorism, which sounds crazy, but that's the argument here. I don't know why he mentioned thumbnails various times, saying that YouTube kind of creates thumbnails, that the thumbnails are published by them, which I'm not positive that argument would hold up. It doesn't make very much sense to me. I know, like, when you're publishing a video, it gives you like a default thumbnail, but that's just anything from the video, really. It would make sense to me that would be considered third-party jurisdiction, but that's not, the argument is that the thumbnails as a part of the algorithm to recommending future videos is considered published by YouTube themselves, because they've taken the information, kind of sorted it out, rearranged it, and then presented it again, and therefore it's them that are the publishers, so they would be liable. And that's kind of what their argument is. So I was going to read this from Justice Clarence Thomas. There was a lot of talk about, from the many justices, pointing out that the algorithms are what they call neutral, meaning that it doesn't inherently promote like ISIS or any terrorist organization. It promotes whatever the individual wants to watch. So there's no rigging of the system in the YouTube AI room to inherently promote one thing over another. It's just what the user wants to watch. And Justice Thomas says, quote, "From what I understand, it's what the algorithm suggests the user is interested in. So if you're interested in cooking, you don't want thumbnails on light jazz. It's neutral in that sense. You're interested in cooking. Say you get interested in rice and pilaf from Uzbekistan. You don't want pilaf from some other place, say Louisiana. So I don't see how that is any different from what is happening in this case. And what I'm trying to focus on is, are we talking about the neutral application of an algorithm that works generically for pilaf and it also works similar way for ISIS videos? Or is there something different?" And the lawyer, Mr. Schnapper, said that's correct. He said, "Our view is that the fact that an algorithm is neutral doesn't alter the application of the statute. The statute requires that one work through each of the elements of the defense and sees if it applies." He says a bunch of other stuff too. We're not going to keep reading that, but that was pointed out. The lawyers representing Gonzalez say that even if it's neutral, if YouTube recreates it, it's still them that are publishers, them that are being held liable. But many of the justices reiterate these same sentiments that they're not trying to really promote any topic over another. It's the individual user and their views that are driving the suggestions. And it's also just important to point out that it's not like there's a person in the back room with a YouTube studio sending out like videos and suggestions. It's way too big of a platform now. It's just not practical. They use machine learning, and I don't know if that changes anything in terms of in court, but I think that's important to point out. When Mr. Schnapper is now being questioned by Justice Sonia Sotomayor, he says, back to the thumbnail, I couldn't really make sense of this, so me trying to say it from a second-hand point of view was not really good. But he says, quote, because a thumbnail is not exclusively third-party material, it's a joint operation. And you can find, if you look at the thumbnail, it'll have a picture which comes from the third party. It has an embedded URL which comes from the defendant, and it might have some information. So I guess he's referring to the defendant. I don't know if in like civil court they still say defendants, but I don't know. I guess that's correct term if he's saying it, but it doesn't really make sense to me too much, because the thumbnail, from what I understand, is purely third party. I make thumbnails for my videos, somebody else makes thumbnails for their videos. I mean, maybe in a technical sense that's YouTube like generating it, but that still doesn't really, I mean, maybe the default, that still doesn't make sense in my head at least. But I'm not on the court, it's up really for them to decide. Let's see what else is good here. So, another good quote. This is Justice Neil Gorsuch, and he says, you got to do something, quote, you got to do something beyond picking, choosing, analyzing, or digesting content, which is what search engines typically do, even as I understand. You got to do something beyond that, as I take your argument. You think that, yeah. So, he says later, quote, so we have a few options. We could say that YouTube does generate its own content when it makes a recommendation, says up next. We could say no, that's more like picking and choosing. Or we could, yeah, that's pretty much sums it up. He kind of goes on to another point after that. I'll just read one other quote here. This is Justice Samuel Alito. And he says, quote, so if YouTube use thumbnails at all, it is acting as a publisher with respect to every thumbnail that it displays, and unquote. And that's kind of the same question I have, really, from Justice Samuel Alito here is, so the argument is that pretty much every thumbnail put into the algorithm for potential recommendation, in the prosecution's eyes, or I don't even know if you call them prosecution, but in the representation of Gonzalez's, the lawyers that represent them's eyes, every thumbnail put into that algorithm is now rebranded and published by YouTube. And so in response, Mr. Eric Schnapper says, yes, they're publishing the thumbnails, and the question is, are the thumbnails third-party content, or are they content they've created? And the problem is, they are content, and I think he's cut off there. But I think that's the question, really. Throughout these arguments, Mr. Schnapper admitted that if I just go onto the search engine, search for ISIS videos, obviously, again, like I said, you can't do that now. They're taken off. In 2015, you could. If somebody did that in 2015, directly, you couldn't hold YouTube because that's third party. You're watching it directly from the third party that uploaded the media. But, and he kind of dwindled his case a little bit, and really what his argument is right here. Is this quote, it kind of sums it up. I don't really think I have to really go to more of it. He says, yes, they're publishing the thumbnails, and the question of this case is, he quotes, are the thumbnails third-party content, or are they content they've created? If the court rules it's content they've created, alright, then pretty much they could be held liable. If it's third-party content, then it's business as usual. And I think I may have pulled up the quote here. I believe it was Justice Kagan. Let's see if I have that. Yes. So I think another thing the court here on your screen is going to kind of think about when they come to determine in this case and the Tom v. Twitter case is that the repercussions for this, if they side against the media sites, is can't even really picture how YouTube would run. So you cannot just have the search engine aspect, but I mean, that's it. Obviously, cases go far beyond just the company they rule for or against, so that this would be really all of the internet. And if they did rule against Google here, the repercussions for that is just hard to think about, really exactly how big of a deal that is. It's really a huge deal that any internet site, and the court could do two things. They could say that that Google's use of an algorithm doesn't apply to 230, that they're not third party. They're not third party. That the algorithms aren't considered third party. It's them directly, YouTube, that's creating it. So they could say it doesn't fit into that statute, and so that would just pretty much be like any internet. If they went that route, any internet that kind of pushes its content, kind of like I know it's really relevant in the Twitter case where you follow somebody on Twitter, it gives you a list of people to follow, a list of topics and stuff, and it doesn't seem like that big of a deal, but this is really looking at being disallowed. If that were to happen, the repercussions were to be really tenfold if that were to happen. And the other thing that could happen, I don't really think is as likely, is for them to say that like 230 is unconstitutional and say that they could be sued, which I don't think is likely. I've people said that at first, and if you really ask my opinion, I don't think either of those things are going to happen, really. And why I think that, I'm going to read this quote from Justice Kagan. She says, quote, yeah, I don't think that a court did it over here. I think that my concern is that's when Mr. Schapper referred to like a ruling from the European Union, and she said, yeah, I don't think that's a court that did it over there. I think it's my concern is I can imagine a world where you're right that none of this stuff gets protection, and every other industry has to internalize the cost of its conduct. Why is that tech industry gets a pass? A little bit unclear. On the other hand, I mean, we're a court. We really don't know about these things. You know, these aren't not like the 9 greatest experts on the internet. And I don't have to... Okay, wait. So she goes on to say, let me see how I can find it. Yeah, she says, quote, "There's a lot of uncertainty about going in the way you would have us go, in part just because of the difficulty of drawing lines in this area, and just because of the fact that once we go with you, all of a sudden we're finding that Google isn't protected. That's kind of why I feel like the court is going to side with Google here. I really do. I would really be surprised if they didn't. Basically because of what Justice Kagan is saying. It would really be huge shockwaves if this went the way of Gonzalez. And it really is unclear where the line would be drawn, as she says. And this isn't a case a lot like many other cases that are like on partisan lines. All of the justices ask good questions. All of them kind of seem to share similar sentiments. And that's kind of why I like the Supreme Court. I think it's one of the most like unbiased
cartridge conniptions. Be conniption free thanks to the
unbiased systems in government, I think, today. And as it should be, as it was designed to be. And I really think that there's not a large chance that Gonzalez is going to win here. Exactly what Justice Kagan is saying. And also, in my opinion, yeah, you could say on a technicality, YouTube put something through an algorithm, but it's the videos of somebody else still that are still being published. So, you know, if I go on YouTube and start going through my recommended, I'm still watching third-party videos. It's just YouTube sorted them out. And I do think that the court will kind of think about the repercussions to this, and if they potentially sided with Gonzalez, and I don't think that's going to happen. I honestly wouldn't be surprised if this was a unanimous decision. It wouldn't surprise me at all, because I feel like many of the justices kind of tipped their hand into how they're going to vote. You know, many of them, as I earlier said, stated out that it's just an algorithm, everything gets an equal shot, it's user-driven, and so it doesn't inherently promote dangerous ideas. It's the user buying into it. Now, maybe the algorithm helps them, you know, leads them down the rabbit hole. Yes, that's true, but just the course of the events of the arguments, I know it's a small sample size, but I really would be surprised, as Justice Kagan said, that they kind of, I'm paraphrasing obviously, but as they go down a steep path, you know, censoring what sites can do, you know, it would be very surprising to me if this goes the way of the Gonzalez's team. And that's pretty much it. Hope this video was cool while it lasted. We'll see how this goes. It'll be interesting, but yeah, that is all. Have a good day. See ya.